They will bring Sedina because you don't do that, you can't get Ken. But if they bring Sedina, she will be sick when she comes, and so she will not see a day in jail. Oh, Sedina will do an appeal, stay pending the appeal, and that the appeal is going to go Sedina's way.
My learned senior Kofi Bentil decided not to do law but politics. The reason why he decided not to do law is that with all his learning of the law, it would be extremely difficult for him to undermine this judgment. He chose the path of politics instead of law. But our training is law. My learned senior pontificates very strange legal proposition.
It was renegotiated. That's what Ofori-Atta did. And the Egyptian company were represented by Edudzi company. If they were charging Ofori-Atta, then it would have been a different matter. You renegotiate, then and sign. So that's a fresh contract. Then you come back and say you hold Sedina again.
Renegotiation, then payment was made?
Yes, by Ofori-Atta. It's not even in 2017, no. In 2018, in 2018, more than 1 year after coming into office, Sedina didn't pay 1 cedi on it. So me, the day I heard that part, I was like, Ofori-Atta again. Can you imagine? Ofori-Atta again.
The MPP held a press conference this week. They said this Court of Appeal decision is a travesty of justice, essentially disagreeing on all counts in the position that the Court of Appeal held to take this decision. I'll start off with you, lawyer Kpebu, on this. And the reason is the former Deputy Attorney General, when I spoke to him this earlier in the week, indicated that's Afetio said, the charges, some of the charges being defective alone cannot be a basis for an acquittal and discharge of Edudzi Tamaklo at Yonu, and that there could have been a way to deal with it. For instance, in starting the case de novo, that's all over again, he cited Section 31 of the Courts Act and Section 406 of subsection 1 of Act 30. Is there a basis for this particular argument?
Look, this is what it comes down to. It depends on your philosophy as a lawyer or as a judge. You see, so there is some room for discretion. What he's saying, yes, Section 31 of the Courts Act and Section 406 of Act 30 are true, right? But in terms of deciding that this is a good case to apply them, would then depend on the outlook, the philosophy of the judge. So what I'm saying, that's what we mean by two lawyers never agreeing on one point. Yes, this one has a different view, the other one has another. So he has quoted his, that's meaning that that's how he would have dealt with it, right? But he's not the judge. That's the unfortunate situation. So in the democracy, he's allowed to hold his opinion. Yes, because, you see, that's the way it is. So I cannot totally say that he's so wrong. No, he's coming from a different perspective, right? Which is in the law, right? And but that's not the end. There are other people who see it differently. Now let's go straight into the case. I'm most interested in the 350 cars. And I said the moment I saw that
procured for GPRTU.
Yes, 350 cars. And
the charge was that they were inflated.
Perfect. So let's come this way. When the MPP administration took over, Ofori-Atta renegotiated the contract. Ofori-Atta renegotiated the contract. If you knew that the contract is so terrible, it's so bad, the overinflation, etc., deal with it legally to abrogate. Right? Because you can show fraud, etc. Deal with it. But you chose to renegotiate. So after renegotiating, how do you come back and still saddle them with the consequences of that contract? It was renegotiated. That's what Ofori-Atta did. And the Egyptian company, so I understand, they were represented by... they were represented by, what do you call it, the Edudzi company, right? Yeah. So once it's been renegotiated, it's difficult. I don't understand why you still want to hold Sedina responsible. If they were charging Ofori-Atta for it, then it would have been a different matter. But once you renegotiate, to renegotiate a contract, you've met a contract, it has certain prices. Then you go into it and say, no, this is too high, this. You renegotiate, then and sign. So that's a fresh contract. Then you come back and say you hold Sedina again. I cannot understand that. Don't touch it. So that part, I disagree with I don't know how he's going to apply sections 31 and then section 406. No.
Renegotiation than payment was made?
Yes, by Ofori-Atta. It's not even in 2017, no. In 2018, I lie. In 2018, more than 1 year after coming into office. So why do you go and suddenly remember? Sedina didn't pay 1 cedi on it. So me the day I heard that part, I was like, Ofori-Atta again. Ofori-Atta again. Can you imagine? How do you renegotiate a contract and then go back and say you are holding the previous person responsible? Then you would find the other parts where Sticker himself came to give evidence. He's PW1.
You mean Dr. Sedina?
Yes.
The Shires MP?
Yes. At that time, he was head of MASLOC.
Yes.
Where he said, part of the charges were no longer relevant, etc. That is Sticker's own evidence. You see? So me, because the age is gone on appeal, as I say, you know the way I do my things, the part I'm very confident of, I'll speak clearly. The one I'm not confident, then I'll leave it for the Supreme Court to decide. So as for the basis side, to the extent that it was renegotiated and so paid under MPP, I don't see how we can hold Sedina. And please, let's repeat, for the avoidance of doubt, the charges are what? 78. So when I talk about these ones don't cover all. And the part where Sticker, that Stephen Amwa, came to admit that the payments were made, the money was duly used, it means that all those charges, I expect that the Attorney General will lose that side. But I'm not talking about all the 78. So I should not be understood to have covered all the 78. No, I'll speak confidently only about the ones that I fully understand. The other ones, it's good. Edudzi has better understanding of the case. So that one, I'll yield to him. Yes,
but then some of the charges were found defective. The courts struck out and dealt with those charges that could stand. And it is not about whether or not...
That's the grounds of appeal.
Yes.
It happens, you know, infelicity of the lawyer. So certain grounds, there are rules on how to frame grounds of appeal. So they found about 8 of the grounds or so, not well laid out. So those were struck out. But there were enough grounds to be able to deal with the whole case. There's one when that can cover everything. When you say the judgment is against the weight of the record, we are not going too technical. Let me make it simple. It just means that there is an omnibus ground that you can use and then you'll be home and dry. So there were sufficient grounds to deal with it. So that's a minor point.
Well, but it is a matter of the state not being able to prove its case beyond reasonable doubt. That's a threshold.
Yes.
That the Court of Appeal was looking for.
Yes.
In a criminal matter like this.
Yes.
But the Attorney General says he is convinced that the charges have merit.
Oh, that's the nature of the law. So the Attorney General takes one position, the accused and his lawyers will also take a different position. And at the end of the day, the judge decides. So let's be very clear. It's not every time that we agree with the judges. No, they may be right. It's also possible that they will be wrong. But they have the mandate to decide. So the Supreme Court, you read something, they'll tell you that, no, yes, that's the way we have seen it, and that's how we decided. You see, and you know the Supreme Court is the final court. So, you ask lawyers, then a lot of cases you go, among us at the bar. You see that as a lawyer, you disagree with them to the end, when you are at the losing end, thinking that your case is right. But that's the nature of law, that one side wins generally, the other side loses. It's more or less a zero-sum game, right? So that's why I said, for me, I don't want to spill too much energy on those ones that you don't have the final say. So the fact that the Court of Appeal is saying these ones, they don't meet the threshold, etc. As I've told you, there are some of them I think there is merit. Other ones, is a court that will decide. You know, we do not necessarily have to always agree. Look, there's one of the facts that the time they were playing out these facts, it never came out. You see, Sedina was said to have met Obatampa and taking cash.
So 500,000 at some filling station in Bachona.
Excellent. Then it turns out that after that date of the cash, there are letters that she's written demanding the money. But throughout...
They're demanding some interest payment.
No, the money as well.
Yes.
Edudzi also. Yes. Demanding the actual money. Yes, I saw that part of the judgment. So I said, we're just told that she received cash. So how come that there are letters demanding the money after that date? So it creates a doubt. If they had gone to prove that, no, this letter is fake, you see, you are said to have collected money on this date, X. So today, 1st August. Then it turns out that you have, so let's say, let's just use the same Sedina. So let's say Sedina is said to have collected the money on 1st August, the cash. So that's in the area of stealing. But it turns out that 8th August, 20th August, etc., she's made demands for that same cash, demand notice. So then it means that, which one is which? So in that case, it means that the state has a burden to be able to prove that, no, these letters are fake. These letters are fake. Because otherwise, it means that you believe in Obatampa over Sedina. Meanwhile, there are documents to show that, no, she also has a defense to it. So that part, I was like, so how come that, of course, that's how cases are reported. Often, we like to give a dog a bad name and hang it quickly. Throughout the discussion on the case, those letters were not mentioned. It was yesterday as I read through in preparation. And I said, there's this one. So that one, there's a doubt in that area. So there are some of the charges that obviously you could see that the state couldn't meet the burden of proof. But I would not stick my neck and say for everything there was no. There are some, I think, that let the Supreme Court decide. So I'm not expecting that in the Supreme Court, the accused should win everything.
The 78?
Yes. Some of them, it's possible that there could be something other than a success for the accused. But others to very, very clear that this kind of charges should not have gone there. As I said, the part about the buses. And when you mention those vehicles, the 350 vehicles, they had a value of what? 61.7 million. 61.7 million Ghana. That's what was paid, the renegotiated price. So that's a huge side of a huge part of the case itself, a very huge part. So that part, I support Sedina that no, she should not be answering for that. Once Ofori-Atta renegotiated with Bedie Etuo, etc., then if they want, they should have charged them together, if they think so. Also meaning that in other ways, nobody should be held for that.
Right.
The buses side. And then the part sticker came to admit that, look, the money was duly used for those services.
But on the 500,000, the only evidence, at least based on what the judgment says, the only evidence tying her to it was a letter she supposedly signed acknowledging receipt. But in the police statement, Sedina had said she cannot vouch that the letter was signed by her, even though the signature looks like hers. So instead of asking whether the prosecution had proved she wrote that letter, what the trial judge asked whether she had disproved it, some have described that as a bit questionable.
Excellent.
And that's what the Court of Appeal found, that the presumption of innocence doesn't ask an accused to clear her name.
Thank you.
It asks the state to establish guilt. The letter was never given properly authenticated. Perfect. As a MASLOC document. So that's on the basis of which the charge fell.
Yeah.
It didn't go through. But the MPP says, and I'm saying, I'll come to you on this, that this is a travesty of justice. This decision by the Court of Appeal to acquit and discharge Edudzi Tamaklo. Why?
Alfred, good morning again to my good brothers here and your viewers. I would have loved to listen to Edudzi before coming in. And then also, before I make any comment, if you'll indulge me, that would be nice. But if not, I can proceed. Would you grant me?
We'll have two sessions on this.
All right. So, you see,
the next 6 minutes.
I want us to depersonalize the matter and look at the issues as they are. That our commitment is to fight corruption without respect to the individuals involved in the matter. So the discussion should be dispassionate, focused on the grand effort to fight corruption. And around this table, all of us are interested in curtailing corruption because of the demonstrable effect it has on our forward march as a country. So it's a matter that there is no disagreement. Now, when there are issues of corruption, our default position as a people should be that we should set examples that would deter people in the future to want to lend themselves to corruption. So I asked the question that in this particular case, where we are nitpicking and looking for grounds to acquit an individual in that exercise where we are collectively in agreement that we want to deter people from abusing their offices, leveraging their offices for personal end, we are looking for nano-micro basis to acquit an individual. It makes nonsense of the whole effort of fighting corruption. That, for me, is the conversation. Not about legal thing, legal that, legal this. Because as my brother Kpebu has demonstrated, in the law, you can always find basis to justify why you won't punish somebody. You can only find it, always find it. And in this occasion, it's been found. Notwithstanding the validation of the judgment by even the US authorities, which was the basis for the extradition. Notwithstanding that validation, because they looked at the case themselves and established and were satisfied that, yes, there's a case here, so therefore the person should go and answer for it. The Attorney General of this republic, while I see that to be a ruse, his points suggest that, yes, there's a basis for why that ruling or that judgment by the High Court should not be overturned.
He says he sees some merit in some of the charges. You say that's a ruse.
I'm saying that.
He's filed a notice of appeal, stay of execution.
I don't disagree. But I'm just saying that it's a face-saving exercise.
The stay of execution?
Oh, yes, of course. Because if you are a government that campaigned that you are coming to fight corruption, and you have come into office, your first order of business was to file nolle prosequi and clear your people. On another occasion, one of your persons who have been jailed or convicted of a crime, you have found grounds to absolve the person from accountability. And you think that Ghanaians outraged about that? You think that the government would just sit back and say, well, I do what I do? This thing is political. We can see it. This government is on a path to set two standards in this country, whereupon some people are more equal and others are not. Some are above the law and others are not above the law. That's the appearance of what we're seeing. It may not be calculated. You can argue, and Edudzi certainly will argue, that it is not contrived to set two standards in this country where some are above and some are not above the law. But that's what is appearing. If you see the processes that have been occasioned since this government came to office, you see clearly that when it has to do with their person, different rules apply. But when it has to do with the other side, different rules apply to them. Or more or less, the regular rules apply to all of us, but different set of rules apply to them. And so I am sitting here and saying, Lawyer Kpebu talks about 31, section 31(2), and makes it looks very light, that, oh, it's more a matter of where you want to put the weight. And it's discretionary, that you can willy-nilly put it here, put it there, and of course the law is just there and it's pliable. The application of that, in favor of the defense cannot be that easy. The threshold of use, otherwise that act is useless to begin with. It says that you cannot overturn a ruling on the basis of technicalities or errors in procedure. It was clear. It's clear on the face of it.
No,
it doesn't require any interpretation.
Of our viewers.
Yeah.
31:2 says, the court shall dismiss the appeal if it considers that no substantial miscarriage of justice has actually occurred, or that the point raised in the appeal consists of a technicality or procedural error,
Right.
or a defect in the charge,
Yes.
or indictment, but that there is evidence to support the offense alleged in the statement of offense, in the charge or indictment, or any other offense which the accused could have been convicted upon the charge or indictment.
So the standard here is that you uphold the judgment and not go on a repeal or overrule the judgment or the prior judgment just on the basis of technical evidence that, oh, the charge sheet was defective, as we are being told in this matter. So in the prosecution application of that act, that section of that act, the standard is high.
But you cannot
that you
accuse-
must meet a certain incontrovertible evidence that there's absolutely no evidence to justify the judgment. So the threshold is high, not to be applied as though that I just feel like it, so I'm going to apply it. No.
But you cannot
You
also
understand?
convict an accused person on a defective charge, isn't it?
But I'm just saying that we are not asking my opinion. We are talking from the Act, what it says. So the Act sets a high standard that in the interest of justice, make sure that you don't reduce this process to say, oh, I see a defect here, so therefore I overturn it. It's subject to abuse if that is the case. You understand? So Lawyer Kpebu's rendition of it makes it as though that if you feel like it in the morning and you decide that you want to just overturn a judgment because you see a defect, do it. He makes it so easy and make it light that you can do it if you want to because there's a defect. But the point is that if there are evidence, in which case there are evidence of the crime being committed. And so the evidence should trump the technicality or the error. So but in this case, the technicalities and the supposed defect trumps the evidence. So now you ask your question, what are we fighting? Are we fighting corruption, or we are examining people on their ability to write charge sheets? Is that what we are doing here? Is that what Ghanaians voted for? That we want to see that lawyers, are we in a classroom to begin with? So that we're examining attorney generals on how they can write charge sheet perfectly? Not on prosecuting crime, which is the substance of the matter. Is it a crime or the writing of the crime? You understand? And that's what we're saying, that you are invalidating the whole commitment to fight corruption. And that's why I'm clear that let's not personalize this. It's a process of us trying to establish deterrence. Okay? Mm-hmm. Deterrence. But here, you give people incentive to feel that the law can exonerate you. All you have to do is bid your time long enough that your party comes to power, and they'll find grounds to extricate you from any charges that you ought to answer to. Is that good for Ghana? Is that how we want to proceed? Is that how we should fight corruption in our country? It's absurd. Completely absurd.
I have been trying to figure out whether they struck out all the charges and whether, in their view, all of the charges were so flawed as to not be upheld.
No, they're defective.
And I think that's... They said, from my reading, it wasn't everything. Mm-hmm. They dealt with a few, and then it seemed they seem to have said that these charges, so many of them are defective, and then they proceed to clear the rest. I'm a bit worried about that. Even one charge is enough to put somebody in jail. And you see, we lawyers always say justice must be done, it must be seen to be done. If justice is done, it is seen. All right? Mm-hmm. And the same happens with injustice. And let me explain. So, before Sedina came to Ghana, there were people who predicted that in Twi we say Yakohu Abrewa, there's Ken, there's Sedina. The pressure for bringing Sedina back or effecting her extradition rose very high because they were going after Ken. And it was clear to many people that, well, to get Ken, they would have to bring Sedina. So people conjecture that they will bring Sedina. Because you don't do that, you can't get Ken. But if they bring Sedina, she will be sick when she comes. I'm saying these are conjectures that people made. And so she will not see a day in jail. You remember there was the whole issue of where is she? All right. And then they predicted that, oh, Sedina will do an appeal. And then they predicted that there will be, a stay pending the appeal, and that the appeal is going to go Sedina's way. I think some of you heard some of these things. And that she will appeal, and they will exonerate her, and she will never see a day in jail. It is worrying, because I have said already that sometimes it seems as if the politicians have dreams, and they make wishes, and then the judiciary delivers it. Okay, one event is not a trend. So you don't create a trend on one event. But no wise person ignores a trend. It started with Justice Tokono. Statements were made before they even came into power. They come into power, something happens. Justice Tokono is gone. You had other situations, GN Bank. Okay, promises were made outside the courtroom. Okay, then somehow the judiciary delivers the dreams of the politicians.
Well, the Bank of Ghana is appealing that now.
Well, as we stand right now, see the trend? No wise person ignores a trend. Some politicians make statements to a certain effect somehow, and then they go on appeal. Same thing happened with Sedina. Okay, people express something before the fact, and then it happens, and then they go on appeal. All right, and you see the series of nolli prosequis. Okay, there is a clear trend that the smart thing to do is, if you get in trouble, find a way to escape and wait for your political party to come into power, and they will clear you. We've seen the nolli prosequis. Nobody can deny there is a trend. Okay, we are being too hypocritical in Ghana, and I'm not saying people should be railroaded into jail when it's not due or whatever it is. But there's a man who liked chichinga, kebab, but one day he saw them slaughtering a cow, and he said, no, they shouldn't slaughter the cow. And they asked him, if you don't slaughter a cow, how will you get your chichinga? Look at Galamsey. We've been crying over decades over Galamsey that no kingpin has been caught or whatever it is. Then the government starts going after people, and one or two people get trapped in the thing. And then you hear all kinds of things. Look at this corruption thing we have been crying about. Okay. And honestly, if there is any benefit of doubt regarding judges, I will give them the benefit of the doubt. Okay. But we lawyers also know that you can argue any side of anything and rationalize anything. Okay. So when you put it all together, it doesn't look like we are serious about fighting this corruption thing, because nobody can convince me, after the work Manasseh did, after the evidence we saw. You go and buy something which on the street is 2 cedis. On the street is 2 cedis. And you alone, when you go and buy it, it comes up to be 4 cedis. And so many different things. The facts were clear. All right? And if even you had issues with some of these, the work of the prosecutor, like Richard is saying, we are not there to judge the work of the prosecutor, although they are important. I have said, okay, and I said it based on the Ofori-Atta case and other things, that we need to look hard at the way our prosecutors proceed, because they mess up cases.
That the question is whether or not the state put up a good case. These 78 charges, was it more of a fishing expedition? Was it
I'm making a general point, and that's why that's
the issue that you're pointing to.
So I don't think anybody doubts that what went on in MASLOC was untoward. And by the way, let me make this call. Abolish MASLOC. Abolish MASLOC. When they started, I remember some of these things that Imani says. They say we don't like anything, and then they will talk about ideology. I think it started during the MPP time. MPP set it up or something. And we said, look, you have all these banks and financial institutions and everything. Today they said they are going to start a women's bank. Okay. And the warning was that be careful about some of these things, because they can easily become slush funds. MASLOC has become a slush fund. Look at the track. Okay? And invariably, more often than not, you hear about they giving loans to political operatives. And they don't recover those loans, and then we end up having problems. So there's another trend there. But the thing is, where there is a crime, as in, or there is, the suggestion that there's been a crime, as was obvious in this case, our prosecutors must be careful. Because my point in the case of Ken Ofori-Atta was that the way they have gone about it, even if the man was guilty, you are going to let him loose. So please, it's coming up here again. All right? However, if you look at section 406 of Act 30, okay, it clearly brings to question what the justices of the appeal court did. Okay? And 406 generally talks about substance and not form. That you don't just throw out everything because there were errors in, certain things, and it doesn't go to the substance. And in one of the statements, I kind of gleaned that the justices were making the suggestion that it goes to the substance. And I was looking for where it goes to the substance. And I didn't see it. So for you to say they did a sloppy job and the job was so sloppy that the crime didn't happen. Okay? I think that if you flip the other side, yes, they have to prove beyond reasonable doubt. But for you to also take it up and throw everything away, you have to prove, at least to reasonable people, that everything that was done was wrong. Look, one charge alone is enough to put a person in jail. Okay? So to suggest, and by the way, she has been acquitted and discharged. Okay?
Which means that any other
charge
is completely
okay.
out.
Now, if you put all of, I said, don't ignore a trend. If you put the sweepiness of the action, everything gone, if you put some of the things that were done, it looks like somebody wanted to just free Sedina. And then you connect it to the things that were said before she came. You ask yourself, where are we going with this corruption thing? What signal does this thing send? So for me, look, let's see how the appeal will go. But I can tell you something here. I don't think that appeal is going to go anywhere.
You don't think the appeal will go anywhere?
I don't think so.
The Attorney General is convinced. He says that, look, he sees merit in some of the charges. And the reason why he's going to court. And on the grounds of appeal, listen to the language of that notice of appeal and the stay of execution. And this is what the Attorney General says. I'm going to read it, at least so I don't take the matters out of... This is it, when he filed. It says that this occasioned a miscarriage of justice. This is the Attorney General speaking. Among other reasons, material errors of law, in fact, apparent on the face of the record. It raises substantial and arguable grounds of law which disclose a real likelihood of success.
I've heard all of that. Okay, but listen.
You still don't believe this?
A carpenter goes to work. His tools are hammers and chisels and things. A lawyer's tools are gowns, dressing, and language. Those are lawyer's tools. Now, and a lawyer can argue anything. So he can say all these things. We will look at the effect. And clearly, it seems every government comes and clears their people. And this government in 2 years, check how many people they have cleared. Check the value, okay, of the charges against them and what could have been recovered, even if we recovered half. We have cases where they say they are going to recover 60% or so. We haven't seen, what has happened with it. Look, my brother Martin is here. Oral, they were jumping back and forth, up and down. How does this play? Like I said, you like teaching, but I don't want to kill the cow. Okay? We cannot say we are fighting corruption when clearly there looks like, it seems like there's a trend where the government is clearing its people, and then they go on appeal, and we don't know what the appeal is going to do, all right? You can argue any side of any issue if you're a good lawyer. So for me, a lawyer's tools are his dressing and language. So composing the language to say, when Edudzi wears his coat and his guy and things, it makes him look like a demigod. And then he will use it. So when you hear some of these things, look at the action. Look on the ground and see what the trend is. So for me, like I said, if there's any benefit of doubt, okay, I will give it to the judges. But it also does not look like they acted in such a way as to make everybody believe that this was clear, plain law at work. And it's sad how people are attacking Godfrey Dame. I have said that I think we should watch our prosecutors and get them to do a good job. But I think people are taking it a bit too far and personalizing this thing over the head of Godfrey Dame. All right? We need to do some of these balancing things and make sure that going forward, we will not come back and say the same things when the table
Is it not because he's the Attorney General?
Yes.
The buck stops with him, is it
Of
not?
course, yes. But I'm saying some of the language is a bit too personal. All right? And as we speak, okay, and I keep going back to the Ken case because the example everybody remembers. No matter what you think he has done, the botching of the prosecution is why we don't have the situation. And like I said from the beginning, Yekobisa Abrewa is in the US. The same Abrewa looked at Sedina Tamaklo's case and said, this one is bad.
amazing.
Take it back. The same Abrewa looked at Ken Ofori-Atta's case and acquitted or basically absolved him twice.
And that was on the immigration matter.
Eh?
That was on the immigration.
judge.
I beg. I said,
A classmate of Ofori-Atta.
you see this? You see? That's why I said we went to ask Abrewa, who is controlling the US courts? Okay, if this happened in Ghana, you can say whatever you want to say, but somebody who doesn't care about you, is not afraid of you, looked at the issue and said that this thing, it doesn't look like you people, you are serious. And I'm making the point that I beg. The justices in the US, Ofori-Atta is controlling the justices in the US. Is that what you are saying? Is that what you are saying? You think they are like you people running around here doing what people
So is that what
you think
that he attended
let me make my case.
Ofori-Atta's son is in the US, etc.
Your son is in the US, so what?
That's why
So what? Martin,
my immigration judges in the US are not independent. No, let's correct him.
No.
Who says immigration judges?
What are you talking about?
They are part of the executive, the Justice Department. Who tells you an immigration
So what is your
judge
problem?
in the US?
So what's the problem?
So you mean
He's not an
Ken
independent.
Ofori-Atta is controlling the
And the
justice
US
system in the
justice.
US? Really?
They are part of the
Counsel,
Justice
let me finish my
Department.
point.
They are not immigration judges.
Oh God!
Please.
They are not
Oh God!
End your point. Yes.
When you hear the name of Ken, you people, your brains break. Listen, I am making a general point, and the general point is we need to make sure we are doing things. And
No. It's not true.
please,
No.
give the rest of my time to.
It's not true. I use only 5
I'm done.
I see. See,
No,
say I use
I'm
7.
coming. Please,
So
let-
I haven't used that time.
I'm
I've
going to
donated the rest of my time to
Everything.
Jampo.
No, it is
There
done.
are
Okay,
perfect
gentlemen. Okay,
timekeepers also, so
let's
keep your time.
keep
Average.
focus. Let's
We'll
keep
keep
focus.
energy
Let's keep
time.
focus.
7
No,
minutes.
no.
Are you the host?
7? No.
Were you the host when you were
Gentlemen.
talking about his time?
Please,
7 minutes.
let's keep
7 minutes.
because I indicated that you said you wanted him to speak first. I said
Richard
make your point preliminary.
Can we
Yes,
crowdfund his campaign?
Have you told me you lose money?
Okay. Edudzi Tamaklo,
The people he's going against are very formidable, so we may want to crowdfund him.
let me bring you on this, and you see on where Mr. Bentil ended about Godfrey Dame. He issued a statement yesterday. He described this Court of Appeal judgment as very weak. That he has read, and I'm quoting from the statement, I have read the judgment and my initial comments are that it is poor in reasoning, poor in analysis, and lacks proper evaluation of the evidence on record. The judgment is very weak and cannot meet legal scrutiny. If the charge sheet, as they claim, was defective, then there are 2 ways or 2 key statutes the Court of Appeal ought to have considered. And that is what I referenced earlier. Section 31(2) of the Court Act is clear that an appellate court shall not allow an appeal on the grounds of a defective charge sheet, provided there is evidence on record to support the conviction,
So actually, I didn't finish.
regardless of how the charges were framed.
Jampo stampeded me out, but maybe this point is important. I was developing a point that we distrust our prosecutors. The evidence is there. That is another reason why the OSP's office should be strengthened and all prosecutions should go there.
Okay.
Because you have a situation where the current Attorney General inherited a case of his personal friend, Sedina. Okay. That thing creates a trust deficit. So going forward, I am looking across the political lines and saying we need, if we are serious about fighting this corruption thing, we need to get to a point where we trust what our prosecutors do and that cases can transit prosecutors and not be so affected by politics, because that's a major problem that we have. And part of what you read is the same, goes to the same point.
Tamaklo,
Professor
I'll bring
Jampo,
you
don't
on
be
board.
stampeding me next time. Let me finish my thoughts.
So Alfred, First of all, I listened to my senior Martin Kpebu. I listened to the other two. And I have no doubt at all that this morning, my learned senior Kofi Bentil decided not to do law, but politics.
Why is that?
And the reason why he decided not to do law, but politics, is that with all his learning of the law, it would be extremely difficult for him to undermine this judgment. And so conveniently, he chose the path of politics instead of law. But our training is law. The politics is just an addition, regrettably. This morning, my learned senior pontificates very strange legal propositions. One is that an American court can have a say on criminal charges filed in a Ghanaian court yet to be determined. Where from this learning, Bentil?
Do you want me to answer?
No.
You don't want me to answer?
No.
Then no, that question is wrong.
Because
wrong question.
the American court does not have supervisory jurisdiction over the Ghanaian court.
Nobody is saying that. When you ask them to extradite somebody, you brought me in. You ask them to extradite somebody. You effectively ask them to look at what you are doing, and they judge it. They said you don't look serious.
Can I proceed?
So don't leave me. Now I have to respond.
As we speak, there is no decision on extradition in respect of Ken Ofori-Atta. Ken Ofori-Atta requested for permanent U.S. residency, among others, and he went before an immigration court. It is that immigration court that had given a decision. There's no question whether Ken can be extradited or not. So what are you talking about?
Nobody is saying that.
The request for extradition by the Republic is yet to be decided. So please don't mislead the public.
Right.
We owe it a duty.
He should make his point.
Right. You see, I have seen a wayward American judge who decided to engage in judicial waywardness by pronouncing on criminal charges filed in a Ghanaian court, yet to be decided. Today, as we speak, the United States of America is fighting even the International Criminal Court.
Yes.
Yeah.
Even the International Criminal Court, Secretary of State Marco Rubio, is saying that the judges there are lunatics. And you have a Ghanaian lawyer. Please, let us not sell our sovereignty for people.
When you extradited people without proper process.
Now let me deal with the substantive matter. First of all, we are being told that when a charge sheet is defective, that defectiveness should be overlooked. Proceed. My Lord Justice Kpega, in his validatory judgment, Osekwejo II and the Republic, said the provision you read relates to Act 30. However, the 1992 Constitution has raised particularity relative to charge sheet to a constitutional pedestal. Article 19, 1D. And for that matter, where particulars are defective, you cannot use evidence to cure that defect. And so if you look, Sedi had two appeals. When prosecution called its 6 witnesses, the prosecution said they have closed their case. A submission of no case was done. One of the issues Sedi raised right from the beginning had to do with the defectiveness of the charge. The High Court judge said, proceed and answer the charges. That submission of no case was appealed against. And if you read the notice of appeal and the grounds in respect of the submission of no case, included the fact that, one of it clearly had to do with the defective charge sheet. So it is in the notice of appeal.
The 2024 one?
Yes. And no, so the first appeal was August 2023. That was when she was called to open her defense. But then they raised that issue. Now, when the judgment was delivered in May 2024, if you look at the notice of appeal filed on the 9th of May 2024, in that notice is the omnibus ground. Which omnibus ground is the fact that the judgment is unreasonable, having regards to the evidence on record. All of us lawyers here seated know that once that omnibus grounds of appeal is raised, the entire proceeding is subject to review. And that is why we say appeal is by way of what? Rehearing. It means that everything that happened at the trial court, the appellate court is put in that position. Obviously, they don't have the benefit of assessing demeanors. Because the trial court is the only one that gets the opportunity to see witnesses and others. The appellate, they are just going to look at just the record without more. Okay. Now, I have heard the former Attorney General, the former persecutor, say that the notice of appeal was not brought to his attention.
Yes.
Yeah, yes.
Can you imagine? Clearly, it shows you that the guy was sleeping on the job.
Well, this is the part of the statement. He says no notice of an appeal filed by Sedina in 2024 came to the attention of the Office of the Attorney General in my tenure.
Please, hold on. I've read the statement.
And deal with the records too.
Please, I've read the statement.
The records were not also filed.
I'll deal with it. You see, Kofi, you're a lawyer. Don't do this.
Hey, Master.
Senior.
Bring me in. I'll
No,
defend myself.
yes, you will. But my point is that as lawyers, there's a bigger standard placed on us. With the greatest of respect to you, you can't speak like Anyaba. He's a politician. He is permitted to express any opinion, anyhow. Desirable. But you, a standard is placed on you. You cannot sacrifice that standard on the altar of political expediency. Why do I say so? On the 9th of May 2024, the notice of appeal was filed at the registry of the High Court. Whose permission or duty is it to serve that notice? Sedi? 2, the point had been made that pieces of the records were even missing. Look, I have with me the decision of the Court of Appeal differently constituted. Because the Attorney General brought an application before the Court of Appeal for rectification of the record. Is that not the procedure that the rules permit when you have issues about the records? Is to apply for rectification. The Attorney General applied to the Court of Appeal, presided over by Justices Georgina Dacha, Amedahe, and another one, who reviewed, in fact, said these lawyers opposed the application on the grounds that the very document they claimed were missing are documents that the prosecution itself disclosed to them. And so for that matter, you cannot be saying that your own document is missing from the record. Said these lawyers oppose it. The Court of Appeal looked at the two sides and came to the conclusion that regardless of the fact, your claim that the prosecution has it already, our decision is that the records ought to be done again and those documents submitted to the Attorney General. Are you aware of that? And so what have you decided to do? Bandy misleading information to cheer up your supporters who have lost an election. Said this is not the reason why you lost your election, a devastating election. Said it's not the reason. Now, there are substantive matters. First of all, the counts were 78. The defective counts were even less than 10. The rest of the charges were evaluated on their merits. You did a shoddy work, poor work. Godfrey supervised a poor work.
That's why he disagrees with you.
And you know why? He never took his work serious.
What do you mean by that?
Yes. And I'll tell you. And you see, sometimes when I listen to Godfrey, I say, look.
I beg, the man is not here. Stop.
But the statement he issued, what do you think he was doing? This is an innocent person that he seeks to attack and destroy.
Who is the innocent person he's attacking?
Oh.
The man is AG doing his work. If he's here, he will defend himself.
Kofi,
but I am complaining.
So let him finish. Let me make my point. Let me make my point. I'm listening to him.
So are you referencing the statement he made?
Yes, the statement he made. I'm not permitted. Who issued the statement?
No, you deal with the statement.
No, Kofi, who issued the statement? What is this trying? Imagine if it's found that there was no notice of appeal. Do you know what Godfrey would have succeeded in doing? Is to undermine even the judges. Why would you have entertained an appeal when there is no notice of appeal?
Are you referencing this particular document?
See the date, 9th. Where is it? The registry of the High Court. 9th May 2024. Signed, High Court, Accra. This is fictitious, shameful. And you think this person should be taken serious? And you see the painful part of this conversation is that, and like I said, this is not one who. In the Atofose matter, the same shoddy work was done by him. What happened? The same High Court judge says the burden was shifted on Atofose. Look, I have always maintained the only work I would do permanent is to be a lawyer. It's to be a lawyer.
Petrol. Right now you sell petrol.
That's why I say permanent. This one is not chieftaincy title. I will leave it. You understand? So I have always been cautious in dealing with legal matters, particularly those that borders on the liberty of an individual. The liberty. You have a situation where the justices of the Court of Appeal had the opportunity of evaluating. And look, I am not surprised. Look, when the Court of Appeal acquitted and discharged Atofose, go and look at Godfrey's statement he issued immediately. Was to attack the justices of the Court of Appeal. That's him.
Because it didn't go in.
Because it didn't go his way. This is an attorney general who today, a former attorney general who today, the disciplinary committee of the General Legal Council had found a prima facie case of professional misconduct against him.
He says the Republic
when was the last time you saw this happen?
Said the Republic had nothing to do in this 2024 matter in terms of the conduct of that appeal.
Look, let me just go
That's
ahead.
what he references.
The office of the Attorney General does not belong to Godfrey Dame. It is an office that continues. The state prosecutor on record, if you read the judgment, the Court of Appeal judgment, you have it.
Yes.
There's a named individual there, Hilda Craig. Mm-hmm. She was part of the people who prosecuted the case before the High Court. She handled the appeal and a different outcome. Unless, of course, my friend here, and listening to Ahiagba has, won't me filed a notice of appeal?
I know that the process underway. I don't know if they're proud.
Yes, this was
so the understanding I get from you is that you expect only one outcome from the Court of Appeal, a dismissal of the appeal.
No, not exactly. I didn't say that. I didn't suggest that.
You didn't know why I asked you that question.
Well, I didn't suggest that.
Think through my question.
Think about what Martin said earlier.
But you see, I asked you this question for an obvious reason.
So that is a blackmail question that you asked.
You see,
it's a trick question.
Yeah, it's a blackmail question.
You see,
what's the point?
You see, the point I am making is that, Alfred, I've heard people who have not even read the judgment pontificate on it. Yeah. This morning, when I listened to my learned senior,
your learned senior Martin says,
no, you.
Your
I'm
Martin
coming.
Listen to him
you
too.
would stay calm.
Rehearing was the normal outcome of this.
Kofi, listen to me.
Depends on your philosophy.
Listen. No, what philosophy?
learned
He is
senior,
not
you
even.
listen to him.
My point is that, Kofi, with the greatest of respect to you, you have not exhausted this judgment. You have not. I've listened to you, and you have not. And you have
Tell
not.
me where.
You have not, because if you read this judgment, it will expose your prejudices.
Where exactly?
What
are you
I've
talking
read
about?
confirms what I've said.
You see,
But you have not read all.
please, the defective
himself
charges,
hasn't read
the defective charges, for instance, count 45, conspiracy to commit crime, namely, willfully causing financial loss to the state, contrary to section so and so. Now listen to the particulars. Sedina Christian Tamaklo Ationo, Daniel Axim, April 2016, in Accra, in the Greater Accra region, agreed to act together with a common purpose to willfully cause financial loss to the state. That's it. Kofi, you read
What's your
criminal
point?
procedure.
Point.
We both did criminal procedure, because without it, you won't be a lawyer. Is that how you put a criminal charge?
Martin is an authority in criminal law. He says the point here, if you read everything,
Martin never said that.
He never said it's an.
Martin,
he is not saying. I am saying.
Please stop.
I am saying he's
Please
an
stop.
authority in that. He says the natural conclusion. I agree with him. That's what I'm saying. So.
Hold on.
You are referring to someone as
He's an authority. Martin is an authority.
Because
they study him in criminal. You bring me in, I'll answer you.
I beg you.
He said rehearing is the normal thing that you should have expected in this case.
If you keep
You
Because
should stay on his case.
if you
and stop
read
calling me.
the counts, a count should be an invitation to offer a defense. So the count must contain an act or omission. Where is it here?
You are wrong.
So please, why am I?
No,
wait,
Mr. Bentil,
For the
stay
public
calm.
sake.
Why
I'll come to
public
you. We
sake?
just note it.
A
I'll
count
come
is
to
not
you.
an invitation to offer a defense. A count is a statement that the prosecution must
Mr.
prove.
Bentil, Mr. Bentil.
You see, you don't even know what you are talking about. Senior.
Okay, no
So
problem.
if you
So
look,
easy.
Yes.
in the Republic versus Ernest Thompson challenged the charges that were brought against him. The High Court dismissed it. He said the charges were defective. It went to the Court of Appeal. He further appealed to the Supreme Court. I invite you to read my Lord Justice Tanko's reasoning. My Lord Justice Tanko took the view that the charge must contain a certain level of sufficiency to meet a constitutional threshold. The lack of it is not cured by amendment. You strike it out. Now, on appeal, if you strike a charge out, everything found on it will collapse. So it is not the charge sheet that was struck out, but specific counts. Those counts that meet the constitutional threshold were allowed to stand. Now, what the judges did, what the judges then did, was now go into the merit, the specific merit of those counts. My senior, what's the name, Martin, raised a very interesting point. Which interesting point had to do with the specifics, the counts. He's done an extremely good job on it. If you pick, for instance, the one bordering on causing financial loss to the states, about the buses, okay? The buses that were
But for GPRTU.
were bought, 350 buses.
Somebody commits a crime.
Your challenge was that
Somebody pays.
he had committed causing financial loss to the state. In the charge of causing financial loss, the fundamental thing that you have to establish is that, in fact, the person authorized payment. Because without it, the charge will not succeed. It is not a charge that is left hanging. The charge must found factual basis. So the justice of the Court of Appeal reasoned otherwise and said, your charge is that A, B, C, D was not done, for which reason you are charging the appellant. By your own prosecution, and guess who the first prosecution witness was? the current MP for Inshiaso, Sticker, he was the first prosecution witness. Now, guess what happened under cross-examination of Mr.
Stephen Amwa.
Stephen Amwa. I always still call him Sticker.
Dr. Stephen Amwa.
Exactly. Under cross-examination, lawyers for Sedi asked him a very specific question. And also the Director of Finance was brought in as the fifth prosecution witness, the Director of Finance of MASLOC. So the question was put to him. I'm trying to retrieve that particular portion. Because you see, Alfred, I think that people need to see what is on record. When you see what is on record, if you can still, in the face of those evidence or pieces of evidence on record, still come to a different conclusion, then yours is just not a question of law, but you are looking at something else. Alfred, permit me to read it.
On where exactly? So that, I mean, while we flip through.
No, I'm going to the records, so the records of proceedings. Sticker. Okay. PW1. You will see his testimony at page 80 of volume 3 of the record of appeal. Page 80 of volume 3 of the records. Question. You also know from your records that the contract for the acquisition of the vehicles had been signed by your predecessor, but not a single cedi had been paid by MASLOC. Is that correct? Answer, yes, my lady. That's Sticker.
That no payments were made.
Yes. Now, at page 294 of volume 3 of the records of proceedings, PW5, the Director of Finance of MASLOC, under cross-examination. Question. Your CEO has testified in this court that they renegotiated the entire contract price. Is that the case? Answer. Unfortunately, I cannot speak on my CEO's testimony. Question. I'm asking you personally. MASLOC says that the contract price was renegotiated. Is that the case? Answer. From what the person gave to me, yes. This is prosecution witnesses. Now again, at page 297, 294 of volume 3 of the records, question, the same Director of Finance. This renegotiated contract was done for how many years after A1 had left office? Answer, I have no idea. Prosecution witnesses. Question, but you will be able to tell the court when the payment was made. Is that correct? Answer, yes. Question, when was it made? Answer, 2018. A1 exited office first week in January 2017. Is that correct? Answer, that is correct.
A1 talking about Sedina Tamaklo.
Yes. And you people sit here and say that she should be put in prison to make you happy.
So,
what kind of democracy are we running? Now, even shocking.
on what basis? And what do you?
I'm doing merit. I mean, I'll yield to them. I invite you, go to the judgment. Page 85. Please, are you there?
Page 85.
85 of the judgment. And so if anybody tells you that this case was lost on technicalities, the person doesn't even know what he's talking about. Ignorance. 85. Again, PW5, Director of Finance of MASLOC, who Godfrey Dami in his wisdom brought to the court as his prosecution witness. When he looked at all the people in this world, he brought PW5 to come and prove his case for him. Competent Dami. Let's see. Question. You tendered Exhibit AD, AC, AB, which relates to payment of end of leave and ex gratia to A1 and her former deputy. Is that correct? Answer. That is correct. Question. The payments were processed by your office. Is that correct? Answer. Very correct. Question. The processing was based on documents relating to the appointment.
Reading court documents.
Relating to the appointment of A1 and her former deputy. Is that correct? Answer. Very correct. In processing for this payment, did you notice anything untoward? Question. No, I did not notice anything untoward. Question. You put your signature under this payment because you did not find anything wrong with this payment. Is that correct? Answer. I authorized those payments because I did not find anything wrong with it.
And this is who speaking?
PW5. Godfrey Dami's witness against Sedina. So if you read this judgment, in the face of this, is that the appellate court, even the Supreme Court, going to vary these records when they are bound by it.
I see.
And so, you see, I have listened to people, I've listened to my two brothers here today, and I'm like asking myself, what kind of justice system do we want? The justice system where my brother Richard Ahiagba can even speculate and conjecture and say that it meets a political convenient statement to put somebody in, even if there is no evidence.
There was a question directed
Richard,
at Martin.
what
Kpebu,
democracy do you think we'll be building?
The NPP cannot be underestimated. You know it, I know it.